I want to share with you about one of the most important documents I pray that you'll never have to use. And that document is the financial power of attorney. Now, before you skip, let me share with you, it's so critically important, especially as we're thinking about retirement, that this document is addressed. I want you to think about it. Hi, I'm Coach Nick, and today we're talking about the financial power of attorney. Let's say you're unconscious tomorrow. Who pays your bills? Who makes your investment decisions? Who pays your taxes? Who addresses your IRAs, your 401ks, your 403bs? Who's handling all of your assets in the event you can't? This document is critically necessary. Let's talk about how this document actually works. Now, I want to remind our audience today, estate planning is state specific. Here in the state of Georgia, as an example, we want a financial power of attorney. Specifically, we want one that has durable language. Now, what does that mean? Well, all financial powers of attorney end at death. All financial powers of attorney end at your incapacity. Well, Nick, the whole reason I did it was in the event I was incapacitated, somebody could help me with these things. I understand. But there's language that needs to be in these financial powers of attorney that are often overlooked. And that language is called durable language. Now, I'm not an attorney. I'm not giving legal advice. I am an estate planner, and this is an area I specialize in. All powers of attorney end at death, period. Now, what a lot of people don't know is all financial powers of attorney also end at your incapacity, with an exception. The exception is that they have what's called durable language in the financial power of attorney. Basically, the durable language simply says, hey, in the event of my incapacity, keep this document in effect, keep it going, which is the whole reason you did that document in the first place. It's important for you to know, I review these documents all of the time. And occasionally, they pop up and they're missing that durable language. The client typically doesn't even know to look for it, and they're surprised. If this is you, my encouragement, go back to the attorney that drafted that document or find another one that specializes in estate planning and make sure that durable language is in that document. Story time. May 8th, 2010, I was in a motorcycle accident. I was riding my Harley Davidson home less than a mile from my house where they say most accidents happen. A young girl hit me from behind at 55 miles an hour when I was completely stopped. Now you can imagine that could be pretty bad. It literally snapped my bike in half and twisted the frame. The police report said it threw me 33 feet into the middle of the road. And by the grace of God, I didn't get run over by an oncoming car. And by grace, let me tell you something, not one broken bone. It was a miracle. Now, I did suffer a lot of hip and low back damage, and as the paramedics, they took me to the hospital, I couldn't hardly lay down. It was so bad. They put me on a significant amount of painkillers to try to help me with all of that pain and all the stabbing and shooting. I tell you guys, it was awful. It was so bad. And the pain management over time, it did help. But because I was on the pain protocol I was also deemed incapacitated. I couldn't drive myself. I actually couldn't make decisions for myself. Even though you and I could have a conversation together, legally, I was not fit to make decisions. I had to rely on my wife, my financial power of attorney, to be able to step in, to communicate with doctors, to communicate with banks, to pay bills, to do all the things that maybe I normally would do and be able to do. But at that time in my life, for about 3 months, I could not. I was not allowed. These documents are important. I want you to think about this. What if my wife needed additional money for my care? Let's say I had $1 million in an IRA. My wife is the primary beneficiary. Surely she can have access to the money, right? Wrong. I didn't die. I'm incapacitated. She has no legal rights to the money. Well, now, because my wife's trying to take care of me and I don't have a financial power of attorney in effect, I don't have one that can be used, my wife now has to petition living probate court. Most of us think about probate court, someone died, but there's also probate court, what if you're incapacitated? So now she's petitioning the court to get access to the IRA to be able to take care of me. That's a bad situation. Do you really think that's what she wants to have to deal with and then report to the court on an annual, quarterly, or monthly basis how she's using that money on my behalf? No, she's trying to take care of me. But that's the reality. That's what would happen. I want to tell you about my dad, Randy Yeomans, the guy who's always watching over my shoulder in the Coffee with Your Retirement Coach podcast. Here's the deal. He's an adventurer, and I love it. The older he gets, the more adventures he goes on. He goes on boats and dives with sharks. Crazy. He goes skiing all over the world. He loves the adventure. He loves being active. The family joke is we're waiting to see him on a skateboard on the X Games. Like maybe that's his next adventure. But I love it. He says, my life motto, I'm old, I can help. I love it. I want us to think through a story. What if Dad is out skiing in one of his favorite places, Park City, Utah? He's out there, he's skiing, having a great day until he hits that proverbial tree. Now, let's say he doesn't pull a Sonny Bono, right? But he is injured and he's bad, and we have to get him home. So we transfer him here to Atlanta, Georgia. And, I am really concerned. We know that he's going to need a van with a wheelchair lift. And so I know I need, X amount of money. I go to the bank. I've got Dad's financial power of attorney. I say, Mr. Banker, please, I need this money to go take care of Dad. And he looks at it and says, oh, it's well documented. It's the right kind of form. Yeah, we'll give that. So they give me $50,000 and I go on my way. The next day, my sister shows up. My sister, the golden child. Hope you're watching, sis. Love ya. So here's the deal. She goes to the bank. She gives him the same document, says, hey, Dad's been in an accident. I need some money to get a van with a wheelchair lift. And here's where it all goes sideways. The banker looks at my sister and says, oh, really? Your brother was in here yesterday. My brother? You didn't give him the money, did you? Well, yeah, he had a financial power. My dad hasn't talked to him in years. Here's the current financial power of attorney. This is the one that you should have accepted. Now, let's just say I was not acting in bad intent. Let's say I actually was in good faith. I didn't know there was another document out there, and I was trying to be proactive. Who's at fault right now? Is it me? Is it my sister? Is it the bank? This gets messy. Here's your 5-star tip. If you have a financial power of attorney, in order to make these things work, there's a few steps you have to take. Number 1, you should send it to all of the financial institutions you do business with. So if that's Fidelity, Schwab, if it's Vanguard, if it is Bank of America, Wells Fargo, whoever your bank of choice is or credit union, who do you do business with? Your insurance companies. Send that financial power of attorney to them and ask them to reply back in writing. In the event I was incapacitated, would you accept this form? Now, Nick, that sounds like overkill. Well, here's the reality. I don't want it might work for me and my family. I don't want, this is probably good. No, I want the highest probability of success that if we had that kind of situation that we were really dealing with, that these documents would work. You're likely going to get one of 3 replies back when you submit these documents to these institutions. Number 1, yes, we'll accept it, no problem. You're going to want to print that email out, that letter out, whatever they sent you, and put it with that financial power of attorney. Keep it in your sexy binder, in your safe, wherever you keep it, not in the bank safe deposit box, right? Accidents happen after banking hours, but you're going to keep it with your stuff. The second thing they could reply is, no, we don't like the language on the second page, second paragraph, blah, blah, blah. At that point in time, you're going to be empowered to make a decision. Do you continue to work with that financial institution and have your attorney change that document, or do you move on and find another financial institution that will accept that document? And then there's the third thing that could happen. They could reply back to you, and guys, this has happened so many times and clients weren't aware. Sorry, we won't accept that. We have our own document. Let me tell you something. One of the worst times that you could find out that that financial institution has their own document is when you actually need to use that document, right? Because then it's too late. If the person's incapacitated, they can't use that financial institution's document. What are you saying, Nick? I'm saying that you should keep these current. Think homemade bread. How long does homemade bread last before it goes bad? I don't know, maybe a day, maybe a day and a half. And then what happens? Moldy and stale, right? Hard as a rock. It goes bad. Financial powers of attorney, they go bad over time. You should keep them updated. Now, again, not legal advice, but I would suggest to you a good practice is to have them updated every 3 to 5 years, even if you aren't changing anything. A fresh wet signature, new witness, new notary, whatever's required in your particular state, and fresh dates. So my encouragement, keep these updated. Now, here's a big landmine I want you to avoid. You know a landmine, right? You stepped on it and it blows up. We want to avoid those. Many times I'm reviewing these financial powers of attorney and I catch something. Many times the people that are putting these documents in place, they're naming one person as their personal representative, and normally if they're married, it's their spouse. And I ask the question to the spouse, to both spouses when they come into the office. Did you guys drive here together today? If you did, one of you should take an Uber home. What am I saying? Accidents happen. And if the only person you named was your spouse, couldn't they get hit by the proverbial, Mack truck? Of course they could. So we want to name a primary person, and our encouragement to you as a best practice is to name 2 backups. So you have a primary, a secondary, and then a third, right? And we want those people in order, and we want them to be aware that they've been named in this document. We also want them to know where to find the document should something happen. If you have an IRA, 401k, 403b, 457 plan, if you own a business, if you're in partnership with somebody, if you own assets in your individual name, this is not a maybe I should do this. This is a must. Make sure you get a good, durable financial powers of attorney, and make sure those institutions you work with, they would accept it. Thanks for joining us today, and thanks for staying coachable.
Investment advice offered through Merit Financial Group, LLC, a registered investment advisor.